right.
And, this is an item that got added late because we had somebody else drop out, but this is vacating opinions. And surprise, surprise, the person leading this is Pam Barron, who's not back on screen yet. So we'll have to wait for Pam. But it's tab I, the August 13th, 2020 memo regarding TRAP Rule 56.2. So as soon as Pam comes back,
Sorry.
we will get after it. Hey, Pam.
Sorry.
I gave you a huge buildup.
What'd you say?
I said, surprise, surprise, leading our final item of the day is none other than Pam Barron.
Well, in the Guinness Book of World Records, I want this to go down as 10 items in a row.
It's awesome. You are
Yeah.
so awesome. It's incredible.
Thank you. All right, last item. Okay, vacating Court of Appeals opinions in moot cases. We have a little bit of an aberration in the appellate rules. And if you turn to page 2 of your memo and you compare Rule 56.2 moot cases with 56.3 settled cases, and you read the last 2 sentences of settled cases that are in bold, it says, the Supreme Court's order does not vacate the Court of Appeals opinion unless the order specifically provides otherwise. An agreement or motion cannot be conditioned on vacating the Court of Appeals opinion. There's no parallel provision for moot cases. And what it provides for in moot cases is simply that the Supreme Court dismisses the case. There's a history of opinions from the court that says merely vacating the judgment, as you would do in a settled case or a moot case, does not vacate the Court of Appeals opinion. If you look at Rule 60.6, though, it does give the court the authority to make whatever other orders seem necessary in disposing of a case. The court had a case this term, Morath versus Lewis. There, the plaintiff sued the commissioner of the Texas Education Agency for violating the statute relating to the STARS exam in a particular year. The trial court denied the plea of the jurisdiction. The Court of Appeals affirmed, finding that the plaintiffs had sufficiently pleaded an ultra-virus claim. The commissioner took it up to the Texas Supreme Court. The Texas Supreme Court requested briefs on the merits. That shows interest in the case by at least 3 justices on the court. And after that happened, the plaintiff filed a non-suit and motion to dismiss as moot. And the commissioner opposed both, but alternatively asked that if you do grant the motion to dismiss and vacate as moot, please also vacate the Court of Appeals opinion. And so the court had to deal with this discrepancy between the rules that address moot cases and those that address settled cases, because in settled cases, it specifically recognizes that the court in its order can, in fact, vacate the Court of Appeals opinion. And the Supreme Court kind of reviewed history or reviewed this disparity in the rules, and really concluded that they've been reluctant in the past to vacate Court of Appeals opinions, but that doesn't mean they don't have the authority to do it. And the lack of a specific provision in the moot cases rule didn't change that analysis. The court did look at Rule 60.6 as giving them the authority to vacate a Court of Appeals opinion in certain circumstances. And then the rest of the opinion, this was issued per curiam this year in 2020, discusses kind of what the criteria would be for doing that. And the court found that this case in particular met it because in this situation, the party that was winning in the Court of Appeals effectively took away the ability of the losing party to ever challenge it by filing the non-suit. And the Court of Appeals opinion, even though the Supreme Court had expressed some interest by requesting briefs on the merits, was basically unreviewable at that point. And it would be precedent for future cases across the state that involve similar facts. And so the court determined that, yes, they would vacate the Court of Appeals opinion in that circumstance. A vacated court, there's a difference when the judgment is vacated, the Court of Appeals opinion remains persuasive authority. Is that right? It's like a writ dismissed case. A vacated Court of Appeals opinion can still be cited. It's still on the books, but it's a vacated opinion. You can just argue it as persuasive in that circumstance. Anyway, the committee looked at all of this and recommends that Rule 56.2 moot cases be amended to parallel the same provisions that are currently included in 56.3 settled cases. So if you look on page 4 of the memo, the underlined highlighted language is exactly what is currently provided in settled cases. And settled cases are really just a subset of moot cases. So it's odd that we even have this disparity. That's it.
Ta-da. All right. Lisa's already got her hand up. Lisa.
Okay, I just want to take a little bit of liberty to my esteemed colleague and mentor, who I adore with all my heart, saying that settled cases are just a subset of moot cases. They actually aren't. At the time that the Court of Appeals, I don't know, and now maybe I'm challenging myself a little bit, but at the time that the Court of Appeals decided the case, it was neither settled nor moot. So it wasn't an advisory committee, an advisory opinion. The problem when you know a case has gone moot, whether it's at that moment at the Supreme Court or moot at some other time that you think it went moot, then you're going into an advisory committee, an advisory opinion that is the Texas Constitution says you can't do. So I took a little bit of issue with that comment, and I am sort of not, I've not found my ground of where I fall on this. I think I wish that the court would be reticent to ever vacate an opinion as opposed to the judgment, but I don't know that I'm opposed to a rule that gives them discretion to do it under certain circumstances. So.
Okay, Frank.
This strikes me as a complete no-brainer. I mean, we're just codifying the rule of morath, and the two provisions should be parallel. However, as we've drawn it, they're not, because 56.3 begins with the words "in any event," and 56.2 leaves out those words. Gosh, the words are different. The provisions are different. Those words must mean something. Of course, they don't. So 56.3, we need to strike the words "in any event." That's it.
Thank you, Roger. You're talking to yourself, Roger.
Yeah, okay. And not getting a very good audience. I understand the value in codifying a rule, but two things. What are we accomplishing here? If all we're doing is what the opinion says, then why codify the rule? And the second thing of it is, I guess I sort of have to ask whether an attempt to codifying the rule is also an attempt to freeze it. I mean, if the court is giving itself a considerable latitude and discretion, the rule may advance, whereas trying to codify it may freeze it. And then the court at some other time will go, well, yeah, but our equitable discretion goes even further. And I really, I don't see this as a substitute. I mean, a subset. When you have a settlement, you know, the parties are effectively agreeing somehow to condition their arrangement on vacator. But when you have either events have superseded a party, or you have a party that goes, hey, I got a great opinion from the Court of Appeals, so let's pull the rug out and live to fight another day because we got precedent on our side. I mean, there may be other situations, but I don't see them as the same. So I guess what I'm asking is, what are we gaining by codifying the rule, and what possible damage are we doing by then, in a sense, freezing the court's discretion on the issue? That's my 2 cents. I'm really not sure we get anything by doing this, and I'm a little worried that we may be putting a roadblock in the way of progress. So I'll leave it there.
Okay, thanks, Roger. Lisa. No, Lisa, got to unmute yourself.
Okay, as I understand the rule is that parties can settle at any time, but the law at the Supreme Court, once they get to the Supreme Court level, the law has developed in a way that the Court of Appeals has stated it at a time when there was not a moot controversy. And so we value the development of the law, and we think we're not going to vacate opinions because the development of the law is as important as anything else. And we see this when we talk about why we love arbitration or not, right? One of the disadvantages to arbitration is there is not the development of the law. These are private things that we don't know how they come out, and we don't know how the law is developed, but with different fact scenarios and different blah, blah, blah. And so the development of the law is actually really important. And that's why we don't let parties dictate whether we're going to vacate the opinion. Like, they can dictate whether we're going to vacate the judgment, because those two are different, as we started today. And so we'll let them vacate, we'll let them ask to vacate the judgment, but we won't let them eradicate the development of the law. What I don't like about moot cases, and again, I'm probably repeating myself, but if it goes moot, we're talking about subject matter jurisdiction. So now we are running up against a Texas Constitution that says no court can give an advisory opinion. Now, when that happens, I know can be complicated and but it is different, because the reason why there are 2 different rules is because one goes to the subject matter jurisdiction of the court, and one goes to jurisprudential or whatever concerns that we might have about the development of the law. And so there actually is a really logical reason why there are 2 different rules.
Okay, thanks, Lisa. Any other comments? Yes, Richard Munzinger.
If I understand the situation, the Supreme Court asked the committee to look at this issue. The Supreme Court is not doing anything regarding its own jurisdiction in this rule discussion. It's looking backwards to the Court of Appeals as to whether it should or should not vacate the Court of Appeals opinion. When the case was heard before the Court of Appeals, presumptively it was not moot. The Court of Appeals had jurisdiction. There were 2 or more parties who were fighting over a point of law, and the Court of Appeals entered an opinion and presumptively a judgment resolving the issue. That's law. And it's law for that Court of Appeals until set aside by the Supreme Court. So now the Supreme Court says, well, wait a second. This case was up here on a petition. I don't know, nor does anybody know what the votes were within the Supreme Court, but the Supreme Court is in a unique position to know whether it is or isn't in the best interest of the state to allow the Court of Appeals opinion to remain in force, because there's now law on the books. As to Roger's question, if the case has been ruled by the Supreme Court to say they have the authority, why would you put it in the rule? So I don't have to brief it. I don't have to go and say, Supreme Court, do you have the authority to set this aside? Don't do this, et cetera, et cetera. I like the rule the way it's written. I think it's necessary, and I don't think it addresses any question at all of mootness at the Supreme Court level. Thank you.
Thanks, Richard. And you've got to change your handle. It just looks like rum to me. So we're going to start calling you Rummy. Nina, and then Pam.
I think Lee some very good points that that the settlement rule is really directed to something very different than the mootness rule. And mootness goes to jurisdiction and what can and can't happen and might depend on the particulars of the case. It's just a very different animal. Whereas settlement, you're letting people know that you can go out there and settle a case and ask us to dismiss, but you can't anchor it to vacating an opinion. So I think that's an important point. So I could see maybe accepting the first suggested additional sentence, but not the second.
Thanks, Nina. Pam.
Well, in Morath, the case became moot because of the affirmative action of a party in dismissing its case. So the party had the absolute control whether or not that case was going to be mooted at the time it was pending in the Supreme Court and when things looked like they were going a little bit south. And in that situation, the court should be able to decide whether the fact that the party has made the opinion unreviewable should be taken into account, and whether it should diminish the persuasive or writ denied type case precedent value. I mean, that case will have precedent in the Third Court of Appeals district for all trial courts, all courts of appeals. It will be considered as a Court of Appeals opinion across the state only because the plaintiffs filed a non-suit at the Texas Supreme Court level.
I understand, but this is broader than Morath. This is all moot cases. So I totally get the issue in Morath, and I think it was correctly decided, but that is not the situation in a lot of mootness situations. That something becomes moot, it has nothing to do with the non-suit.
Lisa,
Well,
or Pam. Point, counterpoint.
whatever. Okay.
No, I'll let Pam. This is an important conversation between three people I very much respect, so I'll let Pam go next.
Now, when you say you respect me, that means you're about to disagree with me completely.
Absolutely.
I'm happy to take the second sentence out if my subcommittee agrees to that. And I do think the Supreme Court, stated in Morath what its criteria are for when it's going to do this in moot cases. It clearly has the authority to do it. We should let people know they have that.
And I just, my counterpoint to that would be like when it became moot. And I think it dovetails perfectly with Nina's comment that things become moot for a lot of reasons at a lot of times. And no one disagrees that it was not moot when the opinion issued. So that court had jurisdiction at that moment. And we're just talking about Supreme Court jurisdiction. And to me, that makes a difference. And look, we could probably, go head to head in a case and totally disagree with that. But just on my initial thing, it's like if the Court of Appeals opinion was issued, I don't know. I feel like mootness and parties in control are very different because one triggers the Texas constitutional provision that our appellate courts cannot give advisory opinions. And so to me, that is probably why the rule was originally written the way it was.
I don't think that's why the rule is written this way. I think what happened is we went back and revisited 56.3 after the court issued its series of procurement opinions saying we don't generally vacate Court of Appeals opinions. I'd have to go back and look, but I'm pretty sure this is a change of somewhat recent vintage, and nobody thought to look at 56.2.
Lisa, are you arguing for the retention of the second sentence, or is your argument that we should delete it?
I think she wants to delete all of, she doesn't want to change the rule.
Okay. Where did she go? She left us. Okay. Because to me, you shouldn't allow private parties to dictate whether a decided case, when the lower court has jurisdiction, vanishes from the face of the earth. That just doesn't seem to me to be right. I'm not an appellate specialist like the rest of you guys, but that just doesn't seem jurisprudentially to be the right thing to do. But that may just be me. Any other comments? All right, Pam, do you want us to vote on the committee's proposal, or do you want to amend it in any way, or how do you want to frame this issue for a vote?
I would vote on it as we propose it.
Okay. Everybody that's in favor of the subcommittee's proposal to Rule 56.2 signify by raising your hand electronically. Everybody finished voting?
Hey, Chip, I'm sorry. I was trying to hit unmute and apparently I did leave. Can you tell me what you're voting on? And then I will cast my vote, and I apologize that I disappeared.
Yeah, I asked you a question, you were gone.
I'm sorry. I was just trying to unmute and then it was like, and I hit leave. Okay, great.
We're voting on the subcommittee's proposal. Everybody in favor is
Okay.
raising their hand.
Thank you.
Pauline, I've got 14, but I may be off.
I show 12.
All right. One of us is off then. Let me try it again. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Now I got 11. Pauline, I'm going to go with your vote.
Okay.
And you got 12?
Mm-hmm.
Okay. All right. Everybody that is against the subcommittee's proposal, everybody drop your hands, and then everybody against the subcommittee proposal, raise your hand. Everybody finished voting, or anybody else want to vote? Yeah, I got 7 on this. Is that what you have, Pauline?
Yes.
All right. So the vote is 12 in favor of the subcommittee's proposal with 7 against. Pam, I'm going to say that this may be the most successful afternoon in the history of this committee.
All right.
Actually, maybe the most successful day. We've disposed of all the agenda items with the exception of item 5, which we deferred. And Marty, remind me to send an email to Judge Rucker and to Richard Orsinger, encouraging them to be at the November 6th meeting. And
Okay.
I will tell them that if I get any back talk, that the chief is going to enter an order. So they better do as I say. Does that work for everybody? Chief Justice Hecht, does that work for you?
It does. That's great. Great day. Very productive.
Yeah, terrific day, everybody. Thanks so much. And we had really good attendance today. So thanks again. And Pam, thank you and the appellate subcommittee for all the hard work you all did. So we'll be in adjournment until November 6th, and we'll be letting you guys know whether it'll be Zooming again or whether we'll meet in person or some combination thereof. So
Skip, I'm sorry, Chip.
Yeah.
We'll still have the option to participate remotely, even if you meet in person.
I think so, frankly. Yeah, I think so.
I'm pretty sure I'm not traveling through the end of the year, so.
Yeah. Okay. Yeah. I'm, odds are there's going to be a total Zoom meeting, but hope springs eternal. Maybe there'll be a vaccine by November 6th.
Oh, yeah, great.
Yeah, probably not. Okay.
Okay.
All right. So yeah, anybody that doesn't want to be in person but wants to participate, we will certainly accommodate that. So, all right, everybody, that's great. Thanks so much again. Talk to you all later. Bye-bye.
Thanks.
Bye.